After that, we will open up the discussions for about 20 minutes, since we must end at 11:15, I guess, 11:10, sorry. And you are all encouraged to participate, whether you are sitting around the table or anywhere else in the room. Just wave and I will find you. For members of the audience, if you could please state your name and affiliation, that would help us a lot. Okay, so let me introduce our panel very briefly. First to speak will be Mr. Furio De Angelis, who is currently the UNHCR current representative in Canada. Furio has held numerous posts in his distinguished career with the UNHCR, including serving as a field officer, protection officer, senior resettlement officer, and deputy representative in various countries, such as Afghanistan, Croatia, Pakistan, Kenya, Ukraine, and Sudan. Furio will be followed by Mr. Andrew Brewer, who is currently Legal Aid Ontario's senior counsel in refugee law. Andrew is a familiar face to many of us in the refugee community. His law practice is focused on defending and advancing the rights of refugees and other non-citizens. Andrew has been associated, among others, with the Canadian Council for Refugees and with the Canadian Association of Refugee Lawyers, and he has appeared before all levels of court and tribunal, including recently at the Supreme Court in a 2015 case concerning the legality of Canada's human smuggling laws. Andrew is also a legal scholar who has published some of the most important papers on the subject of statelessness in Canada. Our next, but not least, and final presenter will be Greg Hero. Greg is a lawyer who is conducting in-depth research on social justice issues for various entities, such as governments, intergovernmental organizations, and NGOs. Recently, Greg provided legal assistance to the UNHCR on refugee law in the Canadian context, and wrote and researched an excellent and long but excellent report for the UNHCR on statelessness in Canada that is available, I guess, today for those who would like to get it. So I thank our panelists very much for being here. So for you, without anything else from me, I turn to you. Thank you.
Thank you. Thank you, Delphine. Thank you very much. And let me see if I can start the usual challenge. Josh will probably help us including my presentation. Where is Josh? So a challenge for me to just review the statelessness international legal framework and situation in the world in just 15-20 minutes. Delphine will keep my time, though I have it here, but I will try to just summarize otherwise concepts which could be discussed and enlarged for long, as you can imagine. So let's start with the basic question: what is statelessness? And we have seen there is a legal definition in the 1954 Convention. A stateless person is someone who is not considered national by any state under the operation of its law. What it means in that respect means that there is a person who just doesn't fit in any provision, in the provisions of any citizenship act which may exist in the world. And this, of course, is an abnormal situation, because we are born and we are grown with the notion that we belong to a nationality. We have a nationality, that means we belong to a situation. As nationality, as you know, has been defined by the International Court of Justice in 1955 as the legal bond having at its basis a social fact of attachment, a genuine connection of existence, interests, and sentiments together with the existence of rights and duties. But these are the key words: social fact of attachment and genuine connection of existence, interests and sentiments. And so you may have stateless persons who have actually these social bonds of attachment, they have these genuine connections, but they don't enjoy nationality, and so they don't have the rights linked to nationality. That's why they say sometimes that stateless persons are also invisible. They are like lost in societies because they are not legally visible. And so how many are around the world? And there is an estimation so far, and the estimation is more than 10 million, maybe 12 million, maybe we don't know. The fact is that UNHCR is collecting data around the world, and so far we have collected only 3.5 billion stateless persons, which are documented in our groups, in our offices. And more or less a third of this number are children. And this is the impact on children, as I said, is a very serious one. Because if we think that a stateless child is born somewhere in the world, at least one every 10 minutes, probably by the end of this conference, we'll have a new classroom of stateless children born into existence. And this is a problem. About 70,000 stateless children are born each year. And you know, in at least 20 countries, these are the data that we recover from our operation. At least in 20 countries, stateless children cannot be legally vaccinated. And there is a report on our website within the I Belong campaign. Recently, UNHCR interviewed some 250 stateless children, and this report is called I Belong. I am here, I belong. And this is the story of these 250 children and how they feel what it means statelessness for them. Where are they? 90% of all stateless persons are in 10 countries, in 10 situations, and these are listed there. And these 10 situations, these 10 countries represent more or less the different causes for which stateless can appear. You have discriminations against different but autochthonous ethnic groups, and this happens in Myanmar, for instance, in Thailand, in Kuwait, in Iraq. Autochthonous groups, but discriminated against. Then you will have a result of migration movement and discrimination. And this would be the situation which is in Ivory Coast or also in the Dominican Republic, here in the Americas continent, with the migration movements usually linked to labor and resulting in generation after generation in statelessness and discrimination, of course. And then the other examples here with respect to the former Soviet Union, Latvia, Estonia, and Russia is state succession, what happens in state succession, and also discrimination. So you see that in all these situations, the key word with respect to the cause of statelessness is discrimination. That's the key the key word in all situation of statelessness. And so we see that the proscription against the discrimination is actually one of the principal constraints on the state discretion to grant or deny citizenship. State discretion is constrained by these proscriptions against discrimination. And the principle of non-discrimination, as you know, is a basic principle which is present in all human rights treaties. And it has been reinforced by the United Nations Committee on the Elimination of Racial Discrimination, particularly on the notion of right to nationality with these quotations I give you now. Deprivation of citizenship on the basis of race, color, descent, national or ethnic origin is a breach of states' obligation to ensure non-discriminatory enjoyment of the right to nationality. So this is very clearly stated in the codification of human rights. And when we see that then the majority of the stateless population belongs to a minority group, and that at least 20 countries maintain nationality laws which deny nationality or permit the withdrawal of nationality on grounds of ethnicity, race, and religion. So we are seeing that still exists in the world an important number of countries that have discriminatory practices, discriminatory legislation in force. And one element of discrimination which is particularly evident in statelessness is gender discrimination. We have 27 countries do not allow mothers to pass on their nationality to children on the same basis as men. There is little to explain here. This is a clear cause of statelessness when women don't have the same, are not compared with men in passing nationality to children. And again, more than 60 countries have laws which do not grant women equal rights with men to acquire, confer, change, or retain nationality. Another cause of statelessness is the conflict and gaps between different nationality laws, and this is mainly based on the fact that the states generally state generally confer nationality at birth on the basis of jus sanguinis, that means father and mothers confer nationality, or jus solis, as it is called, that means being born in a certain territory, or mainly a combination of the two. But when the systems are particularly inclined towards one or the other, then conflict may exist that creates those gaps in which stateless persons are falling. And one particular example, for instance, we have presented here, just an example of a child born and residing in Norway to a Syrian mother and Uruguayan father would be stateless according to the statelessness, to the Citizenship Act of the concerned country, because the Syrian mother cannot confer nationality on a child born abroad. A child born to a Uruguayan citizen acquires Uruguayan citizenship only if he established residence, and this is typical of the Americas continent, which is particularly inclined to the jus soli concept of nationality, as opposed to other regions of the world, and mainly the Arab countries world, which is more on this jus sanguinis. And so this situation is compounded by the fact that Norway doesn't have a safeguard for children born on their territory. And the safeguard on children born on the territory to be given nationality, if otherwise stateless, it's a very important safeguard. It is stated and codified in the 1961 Convention, and is one of the provisions for which UNHCR advocate most, and we have seen that countries recently are coming up and adopting this safeguard because it's particularly crucial, for instance, in this situation. So we are going quick now. And the last of these causes is state succession and transfer of territory, and this was the clear situation of the former Soviet Union, when territory is transferred to another state, so a state disappears and different countries emerge, and conflict of new nationality laws that can emerge and that can bring gaps in the different citizenship acts. And I want to quote here just two examples of good practice in the former Soviet Union, because when that happened in 1991, of course, there was a sort of relaunch of interest for all the enormous situations of statelessness that were created across the territory of former Soviet Union. The different Citizenship Acts were created, but I think two good practices, one in Kyrgyzstan with the new citizenship law of 2007 that created automatic recognition of stateless former Soviet citizens, provided they could provide residence. So automatic recognition combined with simplified naturalization procedures was the combination for which in Kyrgyzstan, for instance, up to 50,000 persons were able to be naturalized and recognized as citizen as part of this new legislation. The other one was also in Russia with the 2002 citizenship law required to submit individual application for naturalization through a simplified procedure. So the simplified procedures appear to be a key way to facilitate the naturalization when new laws are coming up and you have a large number of people which belong to the old systems to be included in the new system. And through simplified naturalized procedures, up to 650,000 stateless persons acquired Russian citizenship in the last 10 years, let's say. And this represents one of the most successful efforts of reducing statelessness in the past years. Besides legislative gaps and problems related to the legislation, there are also administrative obstacles, because sometimes individuals might be entitled to citizenship but actually are unable to fulfill their requirements because of a whole range of administrative obstacles. This could be difficult deadlines, unrealistic deadlines, provide documentations that are not available because they are remain in the old countries where they were, geographic barriers, illiteracy, all these are these administrative obstacles that may be overcome, also, especially by, as I said before, by provide simplified administrative procedures, especially in birth registration and in the naturalization process. We are seeing that these obstacles are particularly difficult to resolve when there is a situation of conflict, of post-conflict situations where things, of course, are more difficult. And birth registration is one of the most important elements of child protection. We are seeing now in the Syrian context how important it is to step up capacity to register Syrian refugees abroad, and mobile birth registration has been one of the systems which UNHCR has put in place, and we have increased a lot in that respect. But if you think that in 2014 in Jordan 2,400 children were provided birth certificates, which appears still a small number, but if you compare that the previous year, 2013, only 300 were registered. So although the Syrian assistance program, of course, is very complex and challenging, and birth registration is absolutely crucial. And in the first years of the displacement, 2012-13 was not that much. As you see, only 300 children were registered in 2015. There was an increase the following year. Mobile registration units are sponsored by UNHCR in different refugee situations across the world, because in refugee camps, sometimes the host country is not able, is not willing to provide resources to go and register children. UNHCR intervenes in financing mobile registration units. I think maybe I managed. Because now on the international legal framework, I won't spend too much time on that, because probably you are aware that there are two major international conventions: the 1954 Convention on the status of stateless persons. This is a convention which is rather similar to the 1951 Convention, was supposed to be adopted together in 1951. Then in 1951 there was more urgency to deal with refugees, and the stateless should have been a protocol added to the 51 Convention, but then the 51 Convention was adopted in 51, and the protocol of stateless became a convention 3 years later. 86 parties at the moment, last one was Turkey, and the next one is the 61 convention. This is on the reduction of statelessness. These are the two main international conventions. As I said, big momentum since 2011, 49 new accessions to these two conventions, and so we hope that with the global campaign of UNHCR and with the international momentum of statelessness, more countries, including Canada, of course, for the 55 convention will be part of this. Signing international convention is important because it's a signal, it means being part of the international codification of international law, and of course for a state is a signal of being part of an international solution, international problem, and the instruments to solve it. Beside the two conventions which are specific on stateless, there is an international array of different instruments that you can see. Also the regional, the American Convention on Human Rights has a specific provision, Article 20, which addresses statelessness. UNHCR has its own mandate. It originates from Article 11 of the 1961 Convention, which provides for a body to be established in order to facilitate the marches of individual stateless with authorities in order to solve their problem. Since the 70s, UNHCR has been recognized with General Assembly resolution to be that body, which is referred to in Article 11 of the 61 Convention. So several General Assembly resolutions have been adopted since, and UNHCR mandate on statelessness is based on these 4 different activities, 4 areas of activities. Identifying stateless where they are, protecting stateless persons according to the rights contained in the 54 Convention, reduce situation of statelessness according to the 1961 Convention, and also prevention also on the basis of 61 Convention, trying to prevent the creation of new stateless cases if there are conflict of laws and all the things we have seen before. So on that basis, 2 minutes for the UNHCR 10 years campaign. Well, I won't say much, then go please today, now, since there is Wi-Fi here. Do we have Wi-Fi in this room? So you can go straight into UNHCR I Belong website campaign. There are already 82,000 individuals who have signed the open letter for supporting the campaign, including prominent Canadians. We are very honored to have among the signatories of the open letter parts of the I Belong campaigns, Ambassador Stephen Lewis, the Nobel laureate Alice Munro, and also Honorable Romeo Dallaire, among those who have endorsed the campaign. This campaign is providing positive trends. It's, as I said, there is a momentum internationally with respect to stateless. In 2015 only, we had 7 new states. 7 new states that have been part of one of the 2 conventions. And the last one in December 2015 was actually Italy, which signed the 61 Convention. So there are also regional conferences, and here in our region, the Brazil Declaration and Plan of Action of December 2014 has a specific part of it is dedicated to statelessness. Different declarations in other parts of the world, and all have relaunched the idea that statelessness is an international challenge, an international problem, and most importantly, as I said, is a problem that can absolutely be resolved. So I will just conclude with as an indication that actually, just as a good practice in terms of the positive trends 4 countries which have done in 2015 have done certain demarches, let's say, adopted legislation, Montenegro, Estonia, and especially on the children born to stateless parents to acquire citizenship automatically at birth, as I was saying before. We had Estonia and Armenia who have actually adopted that provision, just to see how important is that you start from the children and making sure that they have a way to have a nationality if they find themselves in the situation of statelessness. So with these positive trends, which we hope they belong to the I Belong campaign, we hope that we will see more coming in the future, and we are looking forward to, again, working all together for solving statelessness. Thank you, Daphne. Thank you, everybody.
Thank you very much, Furio. Andrew?
Thanks very much. I'll do that. This is working right here. It's an honor to be here with all of you today and on this panel. We've just seen the very big picture about statelessness. I'm going to focus our minds on the very narrow, on the ground picture of statelessness in the context of Canadian immigration, refugee, and citizenship law. I wrote a paper on this issue a few years ago for UNHCR. Just to be clear, I'll be talking about some of the issues covered in that paper. I don't speak for UNHCR, so when I speak today and I'm critical, it's not UNHCR being critical necessarily, it's just me. Furio described the state of play in Canada with respect to statelessness in his opening remarks as sort of a work in progress. I think that's true, but I think more accurately it's called the state of denial. Practically speaking, in the context of refugee and immigration law, statelessness is absent. It's not addressed. And I'm very hopeful that with the new Center on Statelessness, UNHCR's focus, and all of you here today, we can finally puncture that state of denial. And just a quick shout out to one person who has been working on puncturing that state of denial for so many years. He's Advocacy, who is here today from the Center for Victims of Torture. He's the first person I ever heard talk about statelessness many years ago, and has been one of the most faithful advocates on that particular issue for so many years. So thank you, Zach, for being here. My role today is to really deal with some of the nuts and bolts of Canadian immigration and refugee law as it applies to citizenship. And I'm going to talk to you, that my comments are going to sort of track the two conventions, kind of like the paper, which is this one here, was published by UNHCR a few years ago. Kind of like the paper also tracks the work of the 1961 convention, the 1954 convention. As you all know, and as Furio just reminded us, Canada is a party to the 61 Convention on the reduction of statelessness. In general terms, Canadian citizenship law and policy are liberal, and they do generally conform to the obligations, the international obligations that we have as parties to the 61 Convention. Currently, citizenship is granted on both use solely basis and first generation use sanguinis basis. So both to those, you can acquire Canadian citizenship both by being born on Canadian territory and by virtue of having a Canadian citizen parent if you're born abroad, with some notable and problematic exceptions, which we'll talk about later. One of those exceptions is with respect to that generations born abroad. So it used to be that anyone born abroad to just one or two Canadian citizen parents was automatically also recognized as a Canadian citizen. Because of Bill C-37 that came into effect a number of years ago, that ability to pass on your Canadian citizenship was restricted to those who were only the first generation born abroad. So if you are born in Canada, let's say, and you're working abroad, and while you're working abroad you have a child, that child assuming you're a Canadian citizen, that child will become a Canadian citizen as well. But if that child who was born abroad grows up, has a family, has a child of his or her own while abroad, that child, that second generation born abroad, is not a Canadian citizen under the current Citizenship Act. So that's something that I think we need to be looking at and talking about. There is a provision, though, that does allow in